Hello, fellow law nerds. Welcome to another episode of Boom Lawyered, a Rewire News Group podcast hosted by the legal journalism team that really wants to know where it is you get the bags of Skittles that have the fentanyl in them, because I haven't been able to find them, but I'm assured by the Heritage Foundation that that's happening. So I got questions. I'm Rewire News Group's editor-at-large, Imani Gandy.
And I'm Jess Pieklo, Rewire News Group's executive editor. Rewire News Group is the one and only home for expert repro journalism that inspires you to start your mornings with a gentle stretch. We're getting older, Imani. And the Boom Lawyered podcast is part of that mission. So a big thanks to our subscribers and a welcome to our new listeners and viewers.
So law nerds, Jess and I come to you with this episode with a very heavy heart, because we got something wrong.
We did?
Yeah, we did. And it doesn't happen very often. It doesn't happen very often at all. But when it does, we like to be upfront about it. We like to get out in front of it because we think it makes us more trustworthy, right? Like, it makes us like the kind of people who would never, I don't know, slide a razor blade into an apple and hand it out to kids on Halloween.
No,
we're not those kind of people. So today we're going to have to revisit Bostock versus Clayton County. Remember, that's the case that said Title VII forbids discrimination on the basis of sexual orientation and gender identity, right? Mm-hmm. We're going to talk about how, upon reflection, that opinion is just a big fat goose egg. It's a big fat goose egg, and Neil Gorsuch is to blame. Essentially, it wasn't the win for trans people that we needed and that at the time we thought it was and hoped it would be.
Listeners, viewers, it's true. We got way too excited about Bostock in 2020. We did.
I mean, look, in our defense, it was June 2020. We were in the throes of the COVID pandemic, right? We were in the middle of one of the most brutal presidencies in modern history. And, you know, when Jess and I got the news that Neil Gorsuch had written the majority opinion in Bostock versus Clayton County, saying that Title VII forbids discrimination on the basis of sexual orientation and gender identity, we were over the goddamn moon. Like, we were so excited. We even apologized to Neil Gorsuch for calling him Neil Gorsuch for like the first two terms of his tenure, right? We apologized to the man. In fact, Jess even sort of forgave him so much that she was able to become enamored of the man's pandemic beard. Do you remember you were standing the man's pandemic beard?
Look, isolation was rough on all of us, Imani. It really was.
It was.
I mean, look, we wanted that decision to be so much, and we celebrated it. We did, but also,
it was all smoke and mirrors. It was smoke and mirrors, and we almost missed it. We almost missed it.
Almost. I love how we're like, we got things wrong, but not totally, everybody. But you're right, because in that episode, I did raise a red flag about how Neil Gorsuch, while the outcome of the decision sounded really good, managed to write the decision and tailor it so narrowly that it really left open room for future conservative fuckery. Mm-hmm. All right. So let's talk about those cases, because maybe not everybody remembers them. Bostock was a series of cases that involved employees being fired for either being gay or trans on the job. And at issue was whether or not Title VII of the Civil Rights Act, and that's the federal law that prevents employment discrimination, whether its ban on discrimination, quote unquote, on the basis of sex includes discrimination against an employee because they happen to be gay or trans.
And it was, at the time, I remember being so jazzed about the opinion, particularly because it was Neil Gorsuch, and so it split the conservatives, but also because of the way he sort of clapped back to the other conservatives who were basically claiming that, you know, in 1964, no one would have contemplated that gender identity and sexual orientation were meant by Congress to be included in the prescriptions of Title VII. And Gorsuch came up with one of my favorite Gorsuchy lines. Remember when he talked about the canon of donut holes? Like
Oh my God.
CANON, not like
Shooting donut holes out of a cannon. Delicious, not at issue here.
Exactly. But like the cannon of donut holes, he said,
Yes.
there's no such thing as a cannon of donut holes in which Congress's failure to speak directly to a specific case that falls within a more general statutory rule creates a tacit exception. And I just love that language. I love the cannon of donut holes.
It's good language. It's good language. And like Gorsuch was doing a good thing. But in hindsight, all he did was rule that Title VII's ban on discrimination on the basis of sex necessarily includes prohibiting firing someone because they happen to be gay or trans. That's literally all the opinion says in hindsight. Now, okay, this is a big deal. It was the first time that Title VII had explicitly recognized that protection. So we shouldn't just say Bostock is nothing, because that is a big deal. And especially considering the Trump administration had come into these cases defending the actions of the employers here, saying things like, hey, look, they're not actually firing anyone for being trans. They're just firing, or they just happen to be enforcing gender dress codes on the job, right? Like specifically with regard to one of the cases, that was Amy Stevens, who was an employee who transitioned while a funeral home employee. She was told she wasn't being fired for being trans. She just was being fired because she couldn't dress how she was supposed to on the job.
And, you know, it's, as always, I think it's really critical to recognize that these issues don't just affect trans people, right? It bleeds over and affects cis people, which is something like I wish the quote unquote gender critical folks, the rebranded TERFs would understand, right? Because what this is dealing with is the ways in which people aren't conforming to gender stereotypes, right? I mean, that's what this is about. Like, you cannot discriminate against someone for being trans without enforcing stereotypical notions of how gender should be expressed, right? About how gender identity and your sexual organs should align. Like, you can't really do that.
Right. So that was a big deal. Like, the decision itself does stand as a big deal, and written very narrowly to allow conservatives to mess around with it, which we'll get to in a second here. So, as what happens when the Supreme Court issues a new decision like this, the administration goes back and says, okay, now we're going to have to let folks know how to implement it. In this case, that's the EEOC, right? They're the federal agency that's in charge with offering guidance for employers to how to comply with federal law. That's exactly what they did in this case.
So what the EEOC is the Equal Employment Opportunity Commission.
Thank you. I'm just going to whip through all the acronyms today. But in the wake of the decision, the EEOC went back and said, all right, employers, we're going to issue some guidance and offer you some clarity on how to abide by this decision. So they issued that guidance. And here are the things that they said. Employers, use employees' proper pronouns. Okay. Employers, don't prevent trans people from using bathrooms, locker rooms, showers that align with their gender identity. Employers don't force trans employees to dress according to their assigned sex at birth. Okay.
Also seems simple.
And employers, in some cases, if you refuse to use pronouns or names that are consistent with that person's identity, you could be subjecting them to employment harassment, right? That could be creating a hostile work environment for that employee, which means they have action to sue.
So that's like
all really reasonable.
If you're just like purposefully misgendering someone and not using their names, even though you've been told what they are, you're just being a jackass about it.
If I insisted on calling Imani Chad throughout this podcast, for example, that may rise to the level of a hostile work environment, depending on the circumstances.
Right.
All right. So all very reasonable. But then Texas gets involved. Because Texas gets involved. They file a lawsuit. And Imani, I'm going to ask you about this. What happens? We have Texas suing the EEOC. What is happening? What is happening?
Well, essentially, Texas is just being Texas. You know how Texas is. Texas is just so Texas about everything all of the time. Just dial it back a little bit, Texas. But they sued the EEOC challenging the guidance, right?
Okay.
So the crux of the issue in Bostock is whether or not the holding applies only to homosexuality and transgender status, or does it extend to correlated conduct, right? Correlated conduct, specifically sex specific conduct like dress and uniforms, bathroom use, pronouns, healthcare policies, right? Matt
Mhm.
Kasmerak, that's the judge in the Texas v. EEOC case. He's a Trump judge.
That's
He
why my face
ruled.
is doing
I know,
this.
and that's why Jess's face, if you're watching, her face is scrunching up. But he ruled that Bostock was limited to status and did not cover correlated conduct. So he threw out the EEOC's guidance and said, the guidance went too far. So in other words, he ruled that employers can't discriminate you for being trans, but they might have the ability to discriminate against you for acting trans and for expecting your employer to accommodate your trans identity by doing such very difficult things as calling you by your name, using your pronouns, and letting you use the freaking bathroom, right? They can't fire you under Bostock, but they can make your life a living hell.
Sure. So you can like be gay on the job. You just can't be gay
Right.
on the job.
Exactly. Just dial it back a bit. You got to be so gay like when you're working.
I
That's ridiculous.
I mean, I can't help it.
It's ridiculous. So, like I said, Kasmerak is a Trump judge, but I have to say, and I don't like to say this, but I agree with his ruling. I know, Jess, I'm not happy about it,
No.
but I agree with his ruling because Gorsuch left this giant loophole in his opinion, and he left it there on purpose, right?
Mhm.
Bostock protects LGBTQ workers as status, right? Transgender, they're homosexual, whatever, their status. But it doesn't protect the correlated conduct, like how they dress or which bathroom they want to use. Like, Kasmerak says this ran afoul of the APA, of the Administrative Procedures Act, right? Because when the EEOC implemented these guidelines, this guidance, these simple things, don't mess up someone's pronouns. Let them dress the way they want. Let them use the bathroom. Apparently, they didn't implement the guidance through the proper regulatory process, right? Notice and comment where you're supposed to post the stuff and let people comment, then take it into consideration and repost the stuff. They didn't do all of that. And so we just throw out all the guidelines, Jess? Like, is that right?
I'm employing all of my deep breathing techniques right now because I refuse, Imani, to let you get sucked into this
Okay.
distinction without a difference.
Help me, please.
These Trump judges are going to make a mockery of the APA. They are going to tell you that up is down, that a guidance is something substantive as opposed to, guidance.
Okay, all right.
But
So since
like,
I clearly got sucked in, can you explain what the APA is? Because I know you love the APA, so I'm just gonna lean back. You're gonna fan yourself with your papers and just lay it on me. Lay it on
I
me.
need to bring it down a minute, and I literally need to pull myself together here because truly, in the show notes right here, Imani has it saying, Jess, yada yada, APA so sexy, yada yada.
Because I
So
knew you
this
would
is
just take that note and just go with it.
this is my explanation of how the APA is so sexy, everyone. So look, our federal government relies on federal agencies to do its job, right? Congress can't do everything. It can barely do anything. Can you imagine if Congress was in charge of like trying to implement, I don't know, clean air regulations, right? Good luck with that. So the Constitution suggests that Congress can pass off some of its duties. And the Administrative Procedure Act is the federal statute that does that. And it says how these agencies have to operate because there's no democratic check on them aside from our ability to elect folks to Congress and appoint those agency heads and hire the employees. So without getting too much into the weeds, the APA really drives how the federal government does its job. And when those federal agencies have to do things in big, meaty ways, the public gets to weigh in on it. And that's in a process called notice and comment. And that's like if the administration were to do a brand new rule, let's say, tell all automobile industry makers that every car has to be electric in the next 10 years. That's a big change. The public, other interests get the opportunity to weigh in on it. That's notice and comment. Suggesting how a Supreme Court decision works in real life is not substantive. If the administration were to, say, dictate to all automobile industry manufacturers that every car they make has to be electric in the next 10 years, that's a substantive rule. Folks get to weigh in on that through notice and comment. That's literally like type into the federal government, I don't like this, or this is the best thing you've ever done, right? Like that's the process. There's a timeline involved. It's really long. But implementing a Supreme Court decision, how to abide by a law that's been handed down, that's procedural, right? That's the process, the procedure of implementing the Supreme Court decision. So Kaczmarek's wrong. He gets that. I'm
Okay.
sorry.
Yeah, got it. Okay, I feel a little bit better.
I'm not going to let you go to the dark side,
Don't
Imani.
let me go. I'm glad you pulled me back. So the question then becomes,
he gave himself cover, right?
Yeah.
He like wrote an opinion that sounds good. That's what these guys do.
okay, so then the question becomes, did the EEOC skirt the APA, right? Like, that's the question. And I'm going to answer that question because I know the answer now, right? So one of the reasons Judge Kaczmarek ruled in favor of Texas is because he said that the guidance was a substantive rule. And you've just explained how it's not a substantive rule. It's a procedural rule. Nevertheless, that was his claim. That's what he ruled. He said it ran afoul of the APA since it was issued without a notice and comment period. So how is this going to play out in Texas, in the federal courts in Texas? Well, we kind of have an answer to that because we have some precedent there. And we have the kind of precedent that courts are going to abide by, not the kind of precedent that gives people rights and, that the courts are going to just ignore.
They're
right?
like, President Schmessident, rights?
But only when we like it. So the precedent in the Fifth Circuit, where Texas sits, indicates that Kaczmarek's ruling is going to be upheld. And here's why. In 2019, the EEOC published guidance regarding criminal applicant screening policies, right? So when people who have criminal records are going to apply for jobs, the EEOC said that employers have to do an individualized review of each candidate rather than having a blanket policy that they're not going to hire people who have criminal records, right? Texas sued, arguing that this guidance was a substantive rule that needed a notice and comment period before it could be implemented. Now, given what you just said, I know now that this was not a substantive rule either, right? It's procedural. I'm really glad you brought me back because I was stressed out about that. I was like, I don't want to be agreeing with Trump judges. I need Jess's help, right? So the district court agreed that it was not that it was substantive, and then the Fifth Circuit agreed that it was substantive, saying, quote, although the scope of the guidance is purportedly broad, the EEOC has limited rulemaking and enforcement power with respect to Title VII. It may issue only procedural regulations implementing Title VII and may not promulgate substantive rules. So here we seem to have just a difference of opinion, quote unquote, about what's substantive and what's procedural. And given how the Fifth Circuit has already ruled, it doesn't bode well for the EEOC in this particular case involving Title VII and sexual orientation and gender identity.
No, it doesn't.
Yeah.
And it's all garbage and it's driving me crazy. And I need conservatives to leave the APA alone. Okay, leave the APA alone.
Leave the APA alone. Also leave Brittany alone.
I know that you hate the administrative state and that you will do anything you can to burden it to the point and break it so that everybody's like, screw government forever. But we need government to work. And y'all have been messing with the APA. And
she's gonna arm wrestle somebody in the street over it. But
I really am.
Let's talk about how Gorsuch's opinion paved the way for this, right? Gorsuch's opinion expressly leaves open the question of bathroom access, right? Pronoun usage. And if you remember, Gorsuch's opinion was 30 pages. It was tight, it was neat, it was buttoned up. The dissents, 140 pages of just whinging and complaining and discussions, bad faith discussions. And it's too much, Jess. It's too much. What is going on here with this 140 pages of nonsense? And how did we get to the point where Gorsuch is just letting people run roughshod over this Title VII ruling?
I had completely forgotten about the length of the dissents until we started preparing for this show. That's just like go touch some grass, right? Like,
Seriously.
pull like yourselves together, man. I don't know. But I will say now, after having the opportunity to observe Justice Gorsuch in some additional oral arguments and have this sit a little bit, now the bad faith from that decision just oozes through it. And he knew it at the time.
Yeah.
That man's a snake.
And here's what bothers me.
What?
None of this would have happened if trans people had more protection under the law.
Oh, yeah. Okay. I see what you're doing here.
Mhm.
So I guess we have to talk about suspect classes, right? That's what
Yes.
you're doing. That's what this
Yes.
is all about, Imani. I'm
Yes.
picking up what you're putting down, right?
Yes.
Okay, so we're going to talk about suspect classes and if gay, lesbian, and trans folks are a suspect class. So, Imani, are they?
Yes! Yes! Do you remember when Anthony Kennedy retired and we were so pissed? We were so pissed that we co-wrote a piece about it, right? We wrote about how he had essentially destroyed his legacy of LGBTQ allyship by dissembling in just about every case related to LGBTQ issues that came before him in, say, the last decade of his tenure, right? We're talking about Obergefell, which said that, laws forbidding same-sex marriage were unconstitutional. We're talking about Masterpiece Cake Shop, where he said, I don't know, you guys, you're being really mean to this Christian baker, and I feel like you're attacking religion, right? He has talked incessantly about the dignity of LGBTQ people and how it's so undignified to deny them, for example, the right to marry and the right to get divorced, right? But he didn't do what he should have done when he was on the bench, which was advocate for deeming trans people a suspect class, either a suspect class or at least a quasi-suspect class, right? If trans people were a suspect class, then strict scrutiny would be triggered, right?
Right.
And trans people could then start to make equal protection claims under the Constitution as opposed to statutory claims when they are complaining about employment discrimination in the courts. When I say complaining, I mean filing complaints, not like complaining.
Not like whining about it. Right.
Right. So I ask you this question, Jess. What is a suspect class? What is a quasi-suspect class?
I love this. We're going to do some constitutional law nerdery. Because truly what we're talking about here is the difference between, as Imani said, the statutory remedy, right? Title VII, when Congress can change statutes, make them broader, make them narrower. The Constitution is a living, breathing document that lives forever, though, folks, and says that suspect class and deals with how to deal with discrimination. So that's how we get to this idea of a suspect class. And a suspect class is a class of people who have historically been subject to discrimination. They comprise a discrete minority. That means there's not a lot of them percentage-wise, right? And they have some immutable characteristics, meaning characteristics that can't be changed, right? You're born that way.
Right. Ooh,
right?
I like that. Absolutely.
Suspect classifications include things like race and national origin, along with religion. We'll just put that aside.
I'm sorry, that never made sense to me because you can change your religion, but we can move on.
All right. But what's important to know is that laws targeting suspect classes, they're subject to a heightened scrutiny. That's the level that courts use to apply whether or not they're good or not, in order to protect a tyrannical majority from screwing over that discrete and insular majority or minority, right? So let me say that again. Like, the purpose of this is to create a way for courts to judge when the majority is looking to screw over that discrete and insular minority. So, like Imani said, had trans people been deemed a suspect class, then laws that potentially discriminate against them are subject to a much higher level of scrutiny. That means they really got to pass a high bar than, say, another law that applies to everybody, right?
Right. And so, I'm not going to go into grave detail about the levels of judicial scrutiny, although I'm literally dying to, because I love talking about the levels of judicial scrutiny. But let's just say strict scrutiny means that the government has to have a really, really, really good reason to pass a law that otherwise restricts your rights, right? Like, if it's not a really, really good reason, then the law is going to fail.
Yep.
Strict scrutiny applies to race. That's like the
Yep.
main thing that strict scrutiny applies to. Race-based classifications.
Mhm.
Intermediate scrutiny requires just a pretty good reason, right?
Yeah.
Otherwise, a law restricting your rights is going to fail, as long as the state has like a decent reason. And what falls under intermediate scrutiny are gender-based classifications, right? It doesn't reach the level of race-based classifications, but women are a
Yeah.
quasi-suspect class, so we get just like a little bit lower level of scrutiny than race-based
Yeah.
classifications.
And that's mostly because there's just more women than there are, say, Black folks. So it's
Right.
not percentage-wise of a population.
Absolutely. And then there's rational basis review, which I refer to as the fuck it level of review, right? A
Government
court's going
wins.
to look at a law and is going to say, I mean, they had a reason. They
Mhm.
had a reason. It's fine. Fuck it. We're not dealing with it. So
Yeah.
I mean,
Totally.
basically, it's what it is, right? So again, laws discriminating on the basis of race get strict scrutiny. Laws
Yep.
discriminating on the basis of sex are subject to intermediate scrutiny. And then right now, trans people are just sort of left twisting in the breeze, right? The laws affecting them tend to be reviewed under rational basis review, which is just the fuck it review. But how can we have fuck it when it comes to laws discriminating against trans people who are, I would say right now, the most vulnerable population in this country?
Yeah.
Particularly when you're talking about trans women of color, the absolute most vulnerable population. They are a discrete minority. They don't
Mhm.
have a lot of political power. They need protection. They need constitutional protection.
Yeah.
So
Yeah.
I have a question for you.
Okay.
Let's move on to my next question.
Ooh.
What is so scary about this case? Why did we feel like we had to do an episode going back to a case we talked about like a year and a half ago to explain how we got it wrong?
Yeah, no, that's an excellent question. But I think even like you kind of proved the point in this podcast because you were like, I don't know, I kind of see what this judge is doing here. But the reality is Texas versus EEOC is the first high profile case to really weaponize Bostock and try and put queer folks back in the closet at work. And we have to talk about this, okay? Historically, it has not really been safe for folks to be out at their places of employment. And conservatives are looking to take us back to that place. All right. They spent a summer whipping up rage against teachers as quote unquote groomers. We've had these attacks on Drag Queen Story Hour that are just bad faith nonsense. The Don't Say Gay bills at Florida and now at the federal level. These are all attempts at erasing queer folks from public spaces and making it dangerous to be out. Sure, you can be gay, just don't be gay, right? I mean, Imani, we're not that young anymore. Do you remember Don't Ask, Don't Tell, right? That
Yeah.
historically terrible experiment that liberals tried to run in the military that said essentially, look, you can be out in the military, you just can't be out in the military. It's disastrous. And the idea that we won't allow folks to be themselves in their workplace won't be limited to their jobs.
Right.
That will be in all public spheres. And so this is one of those like 5 alarm fire kind of decisions. And we joke a lot on this podcast because we got to laugh to get through it. But this is a really dangerous decision. And there's no other way to talk about it.
We've talked a lot this season on the podcast about how this term is about erasing marginalized people from public spaces. And this is
Yeah,
just another example of that.
completely.
So that's fun. And if you'd like to talk to us about any of this stuff, if you want to talk to us about our mea culpa when it comes to Bostock, or if you want to congratulate Jess for like having that red flag, because that red flag turned out to be very prescient. Very, very prescient. You can find me on Twitter at Angry Black Lady. You can find Jess on Twitter at Hegemommy, HEGEMOMMY. Why? Because she's really, really great.
Oh my God.
I'm sorry. You can also follow Rewired News Group on all of the things on Twitter, on Instagram. You should subscribe to our YouTube channel because that way you can get notifications whenever our podcasts go up on YouTube. If you are tired of looking at our beautiful faces, you can still listen to the podcast wherever you get your podcasts regularly. Apple Podcasts, Google Play, Nordstrom Rack. I don't know what you're doing with your life. I'm not there with you in your house, okay? So With that said, what are we going to do, Jess?
We're going to see you on the tubes, folks.
We're going to see you on the tubes and maybe at Nordstrom Rack.